ruling could have a huge impact on how frequent flyer programs are run in the future. So, do airlines have the right to take away frequent flyer miles, like it or not? Or is there an implicit contract between airline and traveler? Joining me now, attorney and legal analyst AnneElise Getz. I guess, AnneElise, there's more than just an implicit contract. There's a written contract that, in some cases, does give the airlines the right to do this. But I guess the Supreme Court will have to decide whether that's legal or not.
There is a written contract, Graham, and so what we're looking at is, although everyone agrees that there was a contract, and when we talk about contract, we're talking about, when you scroll down the website and you click accept, that's what we're talking about. No one actually reads those contracts, but they do tend to show up again if you're in litigation. So that definitely exists. You sign a contract when you enter into a frequent flyer miles program. But the question is, under state law, there is a implicit covenant or agreement that when you enter into a contract with another party, both parties are agreeing to act in good faith and act fairly towards each other. And that is it's in the law in Minnesota, and this is a Minnesota case. And the question is whether that state law principle is going to be applied to the airlines. And that's what we're seeing right now in the Supreme Court.
So acting in good faith, which is important. It's been held up in the courts for decades, right? So if you were the attorney for this rabbi and the other folks who are saying, hey, don't take away my frequent flyer miles, is that the angle you'd take? Hey, they're not acting in good faith?
That's exactly what you do. You say, look, I understand that there is a federal law out there. There's a federal law that went out in 1978 that says the federal government gets to regulate airlines. But this isn't really airline regulation that we're talking about. We're talking about a plain breach of contract claim. So if I am the attorney for Rabbi Ginsburg, the plaintiff in this case, I'm going to say state law requires in Minnesota, just like so many other states out there, that the parties act in good faith and they have a fair dealing transaction with each other. And this is a pure breach of contract case. It doesn't matter that the contract said that they can terminate and remove all of his miles just like that. They have to act fairly towards each other. And it's a benefit of a bargain type of transaction, which is a fundamental principle in this country to contract law.
That's right. So if you're on the other side then, if you're representing the respondent, what do you argue? Hey, you have the law on your side. You also have this written contract that they click the agree button on.
I mean, you look at both those things, but Graham, it's a tough place to be arguing because what you're seeing, if actually people were to pull up the complaints and read all the briefings like I did, you're seeing that the airlines are saying, we don't have to act fairly or in good faith with you, which is a horrible marketing position to be in as an airline, to go and be making this statement in front of the Supreme Court. But that's what they have to do. They have to say federal law supersedes state law. And it does not matter that we're supposed to have this good faith, fair dealing in Minnesota. That doesn't apply to us. And that's what they're relying on. They're relying on the contract saying you clicked accept, you decided to be bound by these terms, and federal law says that you can't be in charge of the situation.
Right. And, as the pool of carriers, air carriers in this country gets smaller and smaller, and we just had word today that the U.S. Air, American Airlines is golden. It's going to go through. So I think we're down to 4 major air carriers in this country. As that pool continues to shrink, it becomes more of an issue because basically you're creating a monopoly here, and these airlines can say, hey, the heck with you, I don't care.
I mean, and it's fascinating when you think about it, Graham, that this guy took the case to the Supreme Court. I mean, Delta and Northwest, they have lawyered up. They have an entire department within both companies that's purely focused on legal disputes. And this guy spent hundreds of thousands of dollars taking this case all the way to the Supreme Court, basically for people like you and I that would never spend that kind of money to fight if we got kicked out of a program. Now, instead, I'm just going to say, okay, I'm going to go to the other airline. But you're right, as airlines, as there's fewer and fewer options, it's a frightening thing that they've been telling us, okay, well, if you fly us enough, if you buy our ticket as opposed to the competitor, then eventually you get a free flight.
Right.
Well, maybe not so much. We can just take it away from you.
Yeah, and the effects of this ruling are going to be profound one way or another, let's face it. But I got to ask you this, I hope it's okay, we only have a couple minutes left, about the recent changes with the FAA rules regarding electronic devices, i.e. talking on cell phones. Where does that stand right now?
We make some headway with the FAA, and then we make, we're 2 steps back as it relates to taking away our frequent flyer miles. miles. But this is a good thing for passengers. So the FAA over the past few years have been really reviewing the complaints by passengers saying we want to use our portable electronic devices throughout the term of the flight, so both takeoff and landing. And they did all of these tests, and they created a way to figure out whether the plane's communication, navigation, those very sensitive systems will be impacted by the low frequency of these portable electronic devices. And they figured out a test that says whether a plane can or cannot handle that frequency. And to the extent a plane is certified, then you're now allowed to have your iPad, your cell phone, your tablet, those types of devices throughout the entire term of the flight.
See, we always knew that. I mean, in the back of our minds, we were thinking, why do you have to turn off this tablet? Why do you have to turn off your iPhone? It doesn't make any sense. So they were probably doing it out of abundance of caution. But think about the ramifications of this one. I mean, people are going to be on board a 5-hour flight from coast to coast. Somebody's going to be yapping on the phone for several hours. That is just a horrific scenario.
Well, here's the thing. So while we can use the portable electronic devices right now at the FAA, the FCC actually controls whether we can be on the phone or not. So you can have your phone out and you can be calendaring things and playing games, but you can't currently talk on the phone.
Yeah, but that's next. That's coming. I guarantee it, right? That's what passengers are going to demand.
It could be down the pipeline, but because we're looking at the frequency that comes off of these devices, it's going to be a further stretch because phones, you know, by their nature, what they're supposed to do is send out larger frequencies for greater distances.
Right.
And so it's more likely that would impact the plane's navigation communication systems, which we cannot have.
But you
obviously
can use Wi-Fi's. They'll figure out a way, and then that nightmare.
Want it?
That nightmare is going to come through.
For it.
No, I hate it. It's horrible. AnneElise, thanks for all that.
Thanks, Graham.
Coming up next, using Article 5 of